Wednesday, November 28th, 2018 meeting of the Mount Pleasant Zoning Board of Appeals is now called to order. Mr. Ketch, please call the roll.
White.
Here.
Fredrich.
Here.
Orlick.
Here.
Raisinen.
Here.
Berkshire.
Here.
We have a quorum, Mr. Chairman.
Thank you. Our next item on the agenda is the approval of the agenda. Does anyone have any changes they would like to make to the agenda?
I move to approve the agenda as presented.
Second.
All those in favor?
Aye.
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 Any opposed? Okay, next item of business is the approval of the minutes from our October 24th, 2018 meeting. Are there any changes?
Mr. Chairman, I have a few uncharacteristically. We have some changes. Several times the word council, as referring to our legal support, is spelled like city council, so I think those need to be addressed and changed to C-O-U-N-S-E-L. That's under the roll call on page 1, bottom graph of page 3, first full paragraph on page 4, first line right after the ZBA 024 2018 case, also on page 4. The fourth paragraph on page 7, so I think we've stylistically never really taken that up, but I think properly that should be C-O-U-N-S-E-L. Then just a couple of minor possessives. Third paragraph from the bottom on page 3 referred to the appellant's comment. I think we need an apostrophe S, particularly since we're talking about a single appellant. That'll clear that up. So appellant apostrophe S there. Also, one other item on page 7. The third graph, the last sentence, it's talking about a comment I made. I think it should say he wishes the ordinance had tracked more rather than had more tracked. So it should be had tracked more with the Historic District Commission objective. So those are the changes I would suggest to the minutes, Mr. Chair.
With those corrections, is there a motion to approve?
So moved.
Support.
All in favor of the motion, including the corrections?
Aye.
Aye.
Any opposed? No. Hearing none. The minutes are approved with the corrections. On the agenda is communications. Mr. Kench, are there any communications?
I don't have anything to report.
Okay. So we will now open public comment period. This is a time during the hearing where the floor is open to anyone who wishes to come forward and speak. We typically reserve this time for comments that are not related to the case being heard tonight or this evening. Is there anybody that wishes to come forward and address the council? Seeing none, we close the public hearing. Tonight we have one case, ZBA 04-218 at 205 South Main Street, and a rehearing for the Kerr Trust and Estate Elder Care Firms, PLLC. The applicant is requesting a variance from the sign ordinance. Before we do that, I'm going to state the board's procedure. In accordance with our established bylaws and board procedures, the applicant will be called forward to state their case. Following the applicant's presentation, the public hearing will then be opened. Anyone who wishes to address the board will come forward, sign in, and state their name and address, which will be made part of the permanent record. Each person will be allowed to speak for 5 minutes. In addition, each person will be allowed to address the board only once unless they have new and pertinent information to share. The public hearing will then be closed. Any correspondence received regarding the case will be presented to the board. The board will then enter into discussion. All motions will be made in the positive to avoid confusion. This does not necessarily mean that the person making the motion is in favor of the request. It will take 3 positive votes to approve a request. Any request which is denied shall not be brought back to the board for a period of 1 year. The board reserves the right to ask questions of the applicant at any point throughout the hearing. In the event only 3 voting members are present, the applicant has the right to postpone the hearing of the case until the next meeting up to the time their case is called. Seeing as there's 5 members, that doesn't apply tonight. Mr. Kinch, would you introduce the case?
Well, as you know, part of the reason that we're here this evening is following our last hearing, we had a split decision, and we've had our attorney weigh in on that. You have communications from his office. Also, I noted from our previous ordinance that we need 4 positive votes, and with the reduction in our board members under the new code that went into effect in February, we actually need 3 positive votes. So I feel better now to get that off my chest. So, but I want to introduce this case. We're going to give it a rehearing, and we'll allow Mr. Kerr to come up and make his request for a sign variance. As the chairman indicated, we're looking at case number ZBA 04-2018, which is a request filed by David Kerr of Kerr Trust Estate and Elderly Law Firm for a property located at 205 South Main Street. He's looking for approval to place what the ordinance would refer to as a band sign on the fascia portion of the roof that extends out from his facade of his building. Property is located in the CD5 Urban Center District. The use there is conforming. All surrounding properties are located in the CD5, which are commercial businesses, offices, and retail centers. Future land use designation is central business. Becky, can you just turn that off real quick while I run through these so it's a little clearer up on the screen? These slides, they're going to be really text heavy, but they're right out of our ordinance, and we have a lot of illustrations within our zoning ordinance. The section I'm looking at now is referring to band signs under 154.414B. Band signs are required to be placed along the facade of the structure, and the facade by definition is the wall that is located on the front property line. You'll see in here, under this section here with the description, it says a sign that is flat against the facade and placed directly above the main entrance and often runs horizontally along the entablature of the traditional buildings. Band signs are typically intended to be seen from a distance and are often accompanied by additional pedestrian scaled signage. Blade signs, window signage, those types of things. It does allow for 7 inches in depth, which we've explained to Mr. Kerr regarding the pilasters that are on the building, that would be able to set out that 7 inches so that we're not stair-stepping along the architecture. Does that make sense? Definitions as used in the ordinance for facade is an exterior wall of a building that is set along a frontage line, and then it refers back over to the illustration on 154.408B. You can see here, this is our principal frontage. And Mr. Kerr's lot is an interior lot, so we'd be looking here. This would be the side lot line here, and then of course the rear lot lines. Frontage line, these definitions are important because they're used in our sign ordinance. Frontage line is defined as a lot bordering a public frontage, and again refers us back to these frontage lines. This is just an aerial view taken from our GIS regarding how we define and use the terminology in the zoning code. The facade, which is done along the frontage line, is here. The wall that's facing the north, which is on an interior lot, is referred to as an elevation. No signage is permitted on an elevation. If this were a corner lot, it does allow for some secondary signage for corner lot properties. But in this case, we're looking primarily at an interior lot. The area in red is an area that is permitted to have some signage, large projection signs. We talked a little bit about that at our last meeting. And then also, if the roof structure was removed, he could also add an awning sign there. an awning with signage on the valance portion of it, or simply put a blade sign in, or a band sign rather. And here's just a quick and dirty little elevation to kind of give you a sense of what could be done with this property to bring it, to allow sign permits to be issued. Large projection signs could be installed here. In this part of the building, it projects out perpendicular to the from the facade, or the roof structure could be removed in this area, and a band sign could be installed at 1.5 square feet for every 1 foot of width at the frontage line. The other option that you have here would be, again, to put an awning up, a cloth awning or a metal awning, and then the valance portion that hangs down could have signage on that as well. And then the last sign type that would be permitted without approval would be to cover up to 33% of each window in these areas. Okay? And then the section that the board has to weigh the request on is under 154.607. Past ordinances is very similar. We're going to go through these one by one and then identify whether the applicant can comply with these sections to determine that there's practical difficulty and unnecessary hardship to be able to grant this variance request. So I'm going to leave this up here. Do you have questions for me at this time? You know, we've got a lot of information on this case and a lot of different sign types that are permitted. I will say that the roof structure that is on the building is a non-conforming element of the building. If we had a new structure going up, that would not be able to be reconstructed or extended if the corner lot was to be built on. Okay? All right.
Thank you, Mr. Ketch. Yep. Mr. Kerr, would you like to come forward? State your name and address.
I'm David Kerr. 205 South Main is my office in Mount Pleasant. I was pleased Mr. Kinch cleared up the number of votes, because I thought if two of you voted the same way you did the last time, I would only be talking into the teeth of a hurricane here. So I felt that Mr. Zimmerman did a good job presenting the technical aspects of our request last time, and I would like the last meeting included in this meeting. I have a disc I can give you if that's needed, but I request that that be done.
If you have questions for the applicant, we can review some of those comments that were made from Mr. Zimmerman, if that were the case.
I have some more to give, but I do want what was done the last time to be included. So that I have Matt's comments. So I have nothing to add technically to what Matt said. With your permission, I do have some thoughts for your consideration. When I purchased and remodeled the building, I carried the Keystone theme, which you have seen, on the second floor to the first floor. I might also say that Mr. Kinch and I have a disagreement about what I own. You see that little indent up there? That used to be a stairway. And there's a stairway agreement, 3 feet on my side and 3 feet on the other side of the building that burned, the Central Michigan University building. I own the 3 feet that he's got colored being under different ownership. So he and I disagree about his ownership provision. I'm not sure that's critical to this meeting. I didn't know he was going to show this, or I would have sent him some title information.
So, Mr. Kerr, for clarification, you're saying that the shorter yellow line that is indented, you own that, whereas the longer yellow line you do not own?
The longer yellow line, if extended, would be my property. There's a 3 foot, see that little indent? I own that little indent. That there was a staircase agreement when that building was built, 3 foot on one side, 3 foot on the other side. The people in each building had access to the staircase a long time ago. So I did carry the Keystone theme on the second floor down to the first floor, which you saw in the first slide that he provided to you. I added a piece missing at the top of the building in order to carry that outflow over so that it would look nice.
Would you like to go back to that photo?
That's okay. I think they've seen it more than they probably want. I engaged a decorator to help with the color of the building. And when the building next to me burned and was torn down, and the lot owner did nothing to repair the side of the common wall for which they had responsibility, I covered it, and I covered it with something other than straight up and down steel siding in order to have a more pleasant view for the area. My point is that without imposed requirements, I attempted to add to the area. The sign for which I applied was well thought out. And on your sheet, which introduces this, Kerr Trust and Estate, LLC Firm, PLLC, is the name. Not asking for anything else. Okay. It does describe what we do. And I wanted it then, and I want it now, to face the west, as well as people driving by. And if you put the sign underneath the overhang, no one's going to see it. So that's why it's out in front. I wouldn't have any problem putting it, except that I don't like putting it, a band sign over the Keystones, which I brought down to finish the building. Okay? And that's what I would have to do, but nobody would see it anyway. Okay? So that's why I suggested putting the sign where it is. And I don't want to have to tear off the thing that's been there for 50 years. When it snows, and it just recently snowed, there's a path of about 2 feet underneath. It doesn't have to be shoveled right away. It's not a matter of raciness, it's a matter of safety for people passing by. And that's true for the whole thing that goes along there in front of all the buildings that used to be Consumers Power and Mishcon and General Telephone. So because I own the building and because I have a law practice in the building, I think I have a reasonable right to let people know the name of the firm and what we do is a matter of expression as well as a matter of a property right. I believe that this is a practical difficulty, having those rights and not being allowed to do them without making extensive revisions to the building. When drafting an ordinance, the drafters cannot think of everything. For example, awnings with signs have to be open on the sides so that, and the building official has explained that that's so the facade can be seen. However, buildings can have awnings with sides. They just can't have them with signs on them. So it's signs that are being regulated, not awnings. Because if you wanted to see the facades in all the buildings, no awning could have signs. So it's signs, it's speech. The building official pointed out the ordinance refers to the downtown Mount Pleasant signage design guidelines during the last session. And he suggested they be used by the Zoning Board of Appeals. Yet on page 13 of the design guidelines recommended by the ordinance, there's a sign lighted from behind which does not meet the requirements of the sign ordinance. When you're drafting an ordinance, you can't cover everything. There needs to be a place for relief, and this is it, the Zoning Board of Appeals. Sometimes such ordinances are not even sent to their attorney for review for such inconsistencies, such as I have just highlighted. The Zoning Board of Appeals is established to provide relief from these problems. In the last hearing, there was agreement that there are two situations in the downtown area like mine. And that would be the property where Attorney Pat Gallagher has his office and Pradium Realty has theirs. They're all in one building, with signs on the fascia coming down from the structure, which Mr. Kinch and I disagree about whether or not you call it a roof, where there's an overhang, and the Blue Gator. Those are the other two buildings in the CD5 area which have a similarity to me. And I'm not suggesting in this particular form that because they have signs and I do not, that gives me a right under the ordinance to have a sign. I'm not saying that. I am suggesting that it is unlikely that anyone will indicate that they ought to have a sign because you have established a precedent by granting the variance from my sign. I think anyone who might have that argument already has a sign. My building is far removed from Broadway. As you noticed, it's at the extreme block. Okay. Close by to my building are Listening Ear, Blue in the Face, a head shop, JoJo's Junk Shop, and Mainframe, a frame shop. They all have signs and they all face west. They're on my side of the street. All have signs, so granting my sign will not adversely affect them. Across the street is a automobile repair shop at the corner, and Grace Church is there with a huge marquee across the street. I'm not going to hurt them with a sign. Providing a variance for this modest sign will not start any kind of a trend because the circumstances for my building are unique. Based on the building official's current determination, that is the only sign which people can actually see, which I can have, which will face west. He has opined that I can have a sign on the second floor, but it's going to have to face north and south. And I want a sign that will face west and be seen by people passing by as well. Across the street is a parking lot, and I would like people to be able to see it. There are practical difficulties that are exceptional or extraordinary circumstances or conditions applying to the property in question. The variance is used to preserve a substantial property right and expression right. The specific conditions pertaining to the property are not so general or recurrent in nature as to make the formation of a general regulation for such conditions reasonably practicable. If the city commission had to take this up, they'd only be making a rule for one place, me. The authorization of the variance will not be a substantial detriment to the adjacent property, as I've already explained. The authorization of the variance will not materially impair the purposes of the chapter, nor the public interest, at least not from my perspective. And the need for the variance is not created by anything I did or my predecessor did. Finally, something in this matter has troubled me from the beginning. What is the public purpose being served here? I'd love to hear it. How is any public purpose served by denying our law firm the ability to better display our name and that which we do? If I had understood at any point how any legitimate public purpose was being served by denying the sign, we probably would not be here. What is it? Why have I had to go through all this?
Any questions for Mr. Kerr? I have just one. One of the options that was presented was taking down the roof structure, and you've indicated you don't want to do that, but is that a possibility?
No. It's been there for 50 years. It's attached to the other things because it's an integral part of what Mishcon, General Telephone did together. It's one thing. And so if I take it down, I'm going to affect all of them. So no, I don't think taking it down is a reasonable thing to do. Not only that, as I explained, It serves an important function. When it snows, it's safer.
And a awning wouldn't serve the same purpose.
Remember, the awning either has to be a metal thing, which is going to look ugly in my opinion, and if it's fabric, it's going to tear in the wind. I'm eager to see those things when they finally get them up. So I don't think that that's a reasonable thing to do. I think asking me to do a whole repair job on the building is not reasonable.
Any other questions from anybody? If not, I will open the hearing now to anybody who wishes to come forward and speak. If so, please state your name and your address, and you have 5 minutes.
Good evening. My name is Damian Fisher. I'm currently a leaseholder for the property that is just north on there, so that empty lot that's there. And for a matter of clarity,
Your address as well?
201 South Main, that address.
Thanks.
Thank you, sorry. And for a little bit of clarity too, can I see what's, I visited Mr. Kench to look at the details perhaps of the prior proposal. What I saw here tonight wasn't quite the same, or what is Mr. Kerr actually proposing?
This is a rehearing on the band sign. I know we had talked a little bit about.
I saw that picture. Is it one
Just
way or
hit-
the other on here?
Yeah, hit PPP back. It'll take you backwards. Right there.
Is this what he's proposing?
This is what the case that was presented last month.
And this is what Mr. Kerr would like? Very good. Okay. A couple of things. After hearing some of the, I am in development with the present owner of the property north. So we are very interested in what happens with the signage. I personally support Mr. Kerr's desire to increase his signage for his business. It's sorely needed. He certainly has that right. And as I would expect from Mr. Kerr, his legal argument is absolutely on point, and I can concur with his conclusions with that. I'll part in a couple of different ways. First, I would say that to address the one question that was asked about can you tear it down and put an awning up, well, yeah. Would an awning accomplish the same thing? Yes. Is it practical? No. You've got uniformity on this block. Like Mr. Kerr said, that awning, that structure that's there now, predates his use. It's there. If you take one, put his part down, you're going to have a gap tooth, and that whole thing is going to look unsightly. And I don't think that's the aim of the code. And I was involved with what the city did with all that planning, Planapalooza and so forth. So we own this property. I also operate the Gray Sky Gallery, which is at 120 South Main. And we also have an office building right across the street here at 215. So we're all in downtown, and we support local businesses in being successful. I would support Mr. Kerr in this signage. When he says you are here to bridge the code and all the things that couldn't be thought of in the code, this fits that. I mean, even if you thought about an awning, and the question, would an awning serve the same purpose? Yes. Would this serve the same purpose of a band sign or an awning? Yes. It goes both ways. That swings both ways. So is this non-conforming under the code? While I agree with the city's interpretation of the code and these alternatives, yes, I agree with that. Would I love to see that whole block without that structure out there? Yeah, and I'd love to see that awning, because when we build, I'm not going to build that overhang. It's going to be a nice band sign. It's going to be a lot like the Goudreau building across the street, something that bridges the modern and the unique charm of downtown. So Again, so I would support Mr. Kerr's proposal as it's been presented here, and I don't always agree with Mr. Kerr, and in fact, I will part on the public policy part. The public policy here is that so that if I disagree with what he's doing as his next door neighbor, I don't have to confront Mr. Kerr, because nobody wants to confront Mr. Kerr. And so I'll leave it to the public policy behind this for you guys to compel him to do that. And that's where we'll part on where reasonable minds will part on the application of the code. So I agree there is a public policy here, and I applaud you for taking this on and bringing it forward. But I also see that this is a reasonable accommodation between the ban sign, the existing structure, the spirit of the code, and certainly with respect to what's presented here, I certainly would have no objection as his next door neighbor. In fact, I'd get out there and help him put it up. Thank you.
Thank you. Any questions? Anybody else wish to come forward and testify? Hearing none, we'll close the public hearing at this time. Mr. Kinch, is there any correspondence to share?
I don't have anything to share on this case.
Okay. At this time, the board will enter in discussion. Any discussion?
Well, obviously, we're relooking at this again, so some of the things may be reiterative that we're going to say. To me, the key thing in terms of our ability to grant variances is point number one, exceptional or extraordinary circumstances or conditions applying to the property in question. As has been mentioned, there are a couple of other existing properties that have signs which we would say would not meet the existing ordinance. But the fact is, were they to be voluntarily changed or damaged by wind or ice or fire, they could not be put back up the way they are. Do I think that sign that's being proposed is pleasing, does the job? Absolutely. No question. But to my mind, as a ZBA commissioner, I have to say that were we to grant this variance, there would potentially be other properties, newer rebuilds or partial rebuilds, that could then use that to do the same thing. I think the awning is a viable option. I think if we were looking at a different zoning ordinance, we wouldn't have to worry about that. But again, I have to keep reminding myself, we're not the city commission. We have to deal with the new ordinance as it exists. I find that the new ordinance as it exists would prohibit this particular structure. And if we allowed it to be built, to be constructed as is here, there potentially would be several other buildings that could qualify for the same thing. That, to me, in terms of the conditions that we have to find, is the key one. I don't think there's any real debate in terms of any action of the applicant or the previous owner. Absolutely not. We're talking a long time ago in terms of some of this, even in terms of virtually predating our ordinance. This would not be a substantial detriment to the adjacent property, fine. But to me, the key thing is this is simply not exceptional or extraordinary, and under the ordinance that we are duty-bound to deal with, I don't think we can afford to set the precedent.
Thank you.
Go ahead. I'd like to comment that one of the concerns I voiced last month was in reference to the work that the Historic District Commission has done to encourage preservation of the historic feel and nature and charm of our downtown. And thanks to very knowledgeable city staff, I have read through the zoning ordinance in greater detail, and I think there are some things moving forward that the Planning Commission can discuss and perhaps incorporate. However, Commissioner Orlick is right. This is not exceptional or extraordinary. So I just want to say that I think that those concerns we raised last month about requesting people change the look and feel of their structure, I think those have been addressed and will continue to be addressed, especially now that they've been brought to light. So.
Other discussion from anybody else?
I'd just like to make, back to, we were talking about the 154, 608B, the number one, as Mr. Orlick was referring to. I look at it a little different. I find it extraordinary for the simple fact that you have that common structure that runs across whether it's two different property owners, I don't know who if the other two pieces of the building are same ownership, they look like they may by the window, but the practicality of trying to remove a portion of that when that was built 50 years ago, whether structurally sound, whether that could affect that adjoining property by tearing that down and having to go in and try to make sure that that's built still safe, but on a piece of property that's not his own, to me is a lot to ask for someone to do. I agree by taking it down, and the ban sign would answer all the questions and concerns of everyone. But I feel, and I could go back and look at the awning deal with, if he was to rip it down, put an awning, he still would not have all sides open because he'd be butting up to the one side of the roof that's already there. So it would still not, to me, so I feel that what makes that extraordinary. And I think to be the practicality of putting that sign underneath on top of the columns just wouldn't fit with the area, and there's just not room. The slope, the height, I just don't. That's how I feel that makes it extraordinary to be. It's like I said, I agree with Commissioner Orlick. If those were all to blow down with ice, absolutely nobody would be able. They just wouldn't be allowed to go. So there wouldn't be a question. There would be ban signs in front. They wouldn't be put up. But it's not the case here.
Yeah, we are certainly, constrained by the realities of our role and the realities of this particular structure, but structures in general and what the new ordinance allows us to do. I can depart for just a moment. I'm reminded of the case in a zoning board in another state where you try to deal with some difficult circumstances. There was a building shared by two owners, and they had to share the sign. One owner or one operator was a veterinarian, the other one was a taxidermist. And so they came up with a one-sentence solution. Either way, you get your dog back. Sometimes
That is terrible.
Sometimes we're put in very peculiar positions. I would like everybody to get their dog back in this regard, meaning I really hope that we take this case and look at it, as Commissioner Rissanen said, we look at it in terms of maybe being able to do some things that will prohibit, that would promote this as a general sort of thing, rather than putting us into the position of setting a precedent that would be contrary to the ordinance as it exists.
I guess my view is I agree with Commissioner White that I do think it's exceptional in this particular case because the structure has been there for a long time. Any other alternative I don't know is feasible other than tearing down the structure and replacing it with an awning or just with the band side on the facade. So I think the other 5 issues I think are met as well from that perspective. So.
I have a question for Mr. Kinch. Can you forward our slides to show the grayscale drawing of possibilities?
Yeah, we're focusing primarily on a band sign, but keep in mind the large projecting sign is something that they can still do.
Well, that was
And the window
exactly
signage.
why I wanted to see this slide again, because that it would be considered a blade sign, correct?
This is considered a large
A large
projecting sign.
projecting sign.
This gives him more signage on the building than what he was planning to do on putting it on the fascia. And for the record, I may want to add, we are also, city staff is working on another property that was mentioned this evening regarding taking enforcement actions for a similar sign that went up on a roof structure. So we're consistent in our interpretation. We have one that we're doing enforcement. We're doing one this evening that we're looking at trying to grant a variance.
So,
And that person put the sign up without going through you?
That's correct.
Okay.
the reason that I wanted to see this particular slide again, to my fellow commissioners, because I hear what Commissioner White and Chairman Berkshire are saying, but this rendering shows that there are other options that don't require taking down the roof.
Oh, it does take down the roof on his part
No.
of the property.
Large projecting sign.
The large
The
large
sign.
projecting sign would not take down the roof.
Okay.
So he has options that don't require the roof removal that are in line with our ordinance. So I just wanted to point that out because I can see your point saying that the fact that the roof is shared with other properties could be considered extraordinary. If there were no appropriate options existing in the ordinance, I think that argument might carry more weight.
You have other roof structures in the downtown as well. I think some of the taverns, Cheers, I know, the party store in the corner of Main and Broadway. So, did you want me to leave the slide here, or want me to go back? I'll leave it there.
Thanks.
Other discussion? Do I have a motion? Again, the motion has to be in the affirmative.
Can I make it pretty simple that I move that we grant the variance as requested in ZBA 04-2018 for the signage variance at 205 South Main?
I think we've already discussed the 6 items, correct?
Those want to be included in the motion in some
So
fashion.
do you want these included in the motion? Our discussion about these 6 items?
Yeah.
Shaking his head.
Okay, so let's see if I can do this. Because we're making it in the positive. So I so move that we grant the variance for a sign as requested in ZBA 04-2018 at 205 South Main Street, because there are exceptional and extraordinary circumstances to the property. The variance is necessary for the preservation and enjoyment of the property right. The variance is not one where the specific conditions pertaining to the property are so recurrent that we would be making a general precedent. That authorization of such a variance will not be a substantial detriment to adjacent properties. The authorization of the variance will not materially impair the purposes of the chapter or the public interest. And lastly, that the need for the variance is not created by an action of the applicant or previous owner.
Do you want to articulate on why on some of those?
I would suppose, ask Mr. Wood maybe, or maybe you, Mr. Kench. For number 1, since there's disagreement on that, can we state both sides of that as part of the motion?
I think we're going to be
Yeah, it would be cleaner if you're, depending on what your outcome is going to be, if you make a motion to approve it and you don't have sufficient votes, then you should make a motion to deny it and state why. And if you approve the first motion, obviously the second one is not necessary. But that leaves a cleaner record.
Okay, so we don't need to make that part of this particular motion.
I think the motion that she stated it is fine.
Okay. Do we have a support?
Yep.
Okay. Any discussion on the motion?
Would you like a roll?
If not, we'll vote by roll call.
White?
Yes.
Friedrich?
No.
Orlick?
No?
Reasonen?
No.
Berkshire?
Yes. Motion fails.
Motion failed. I would ask that we have a motion to deny.
Motion
I'll make,
failed.
oh, sorry.
Motion failed, so we need a motion to deny at this point.
I'll also make that motion. I move that we deny the request for a variance in ZBA 042018 at 205 South Main because this property does not exhibit extraordinary or exceptional circumstances because there are other buildings in the area that have similar situations and similar constraints when looking at signage. There are other options for the applicant to create signage that do fall in line with the ordinance and would not necessitate a variance from our ordinance. I also do not think that the variance is necessary for the preservation and enjoyment of Mr. Kerr's property rights. I do think that granting this variance would create a situation where we would be opening this body up to additional requests, similar requests in the future for various and variety of reasons from other business owners. I do not think that should we have granted the variance that it would have been a detriment to adjacent property. I do not think that the variance would have impaired the public interest, but I do think that it could have impaired the purposes of this zoning ordinance. And I do not think that the request for the variance was caused by actions of the applicant. So since we could not meet all of the findings of fact in order to grant a variance, I move that the variance be denied.
Is there support?
Support.
Any discussion on the motion?
Yeah, I think it's one thing that we need to reiterate in terms of point 2, in terms of criteria number 2. Necessary for the preservation and enjoyment of a substantial property right possessed by other properties in the same district or city zone. The fact is, no other property would have the right to do this were they not grandfathered in. And that's the crucial point. We can look at some others but they're doing this. The fact is they're grandfathered in. And to me, when we're talking about a substantial property right, we have to go with what the ordinance says. Take out the grandfathered ones until such time as they have to conform.
Thank you for that clarification.
Other discussion?
How will this, we'll vote on this one again? So.
Yep. Do we want a roll call again? Yes.
Yeah.
Okay. Mr. Kench, call the roll.
White?
This does not have to be unanimous, does it? I mean, it just, I'd say no.
Friedrich?
Yes.
Orlick?
Yes?
Reasonen?
Yes.
Berkshire?
Yes.
Motion passed.
Motion passed at that particular case. Okay. On the agenda, is there any old business?
Well, nothing to report.
If not, new business.
For new business, we don't have anything as far as new applications to present in December. We believe we may have an application in January. Regarding other business, I would suggest that we have a couple of amendments that we want to make to our bylaws, and staff will put those together and get those to you during our next meeting for review, and then we'll get those adopted.
That's what I was going to ask at this point, Brian, because we had right up in terms of the role of abstentions, and I think that caught us all off guard. I've been on and off of this board since the 70s, and that's never come up before, which means to say, in all the time I was on it, we've never had an abstention, and so there was never any reason to deal with this issue. So I think that's an important one that we do deal with and make sure that it is according to statute.
We'll add some things in there about Robert's Rule of Order, that type of thing, too. So we'll take an opportunity to go through it again.
Okay.
And that's all I have.
And that will probably be at the January meeting.
That'll probably be at the January meeting, I would suspect.
Right. Any, go ahead.
I'd just like to thank Mr. Wood for yet another really well-written, understandable brief. I really appreciate the work that you do for this body.
Thank you. It's been a pleasure.
Great.
Motion to adjourn.
Support.
All in favor?
Aye.
Aye.
Any opposed?